Aguinaldo v. Santos. Facts: petitioner was the duly elected governor of the province of Cagayan. Shortly after the December 1989 coup d'état was crushed, the Secretary of Local Government sent a telegram and a letter to petitioner requiring him to show cause why he should not be suspended or removed from office for disloyalty to the Republic. Within 48 hours from receipt thereof, a sworn complaint for disloyalty to the Republic and culpable violation of the Constitution was filed by Veronico Agatep, Manuel Mamba, and Orlando Agatep, the mayors of the municipalities of Gataran, Tuyo and Lazam, all in Cagayan, against petitioner for acts the latter committed during the coup. In his letter, petitioner denied being privy to the planning of the coup or actively participating in its execution, though he admitted that he was sympathetic to the cause of the rebel soldiers. The secretary suspended petitioner from office for 60 days from notice, pending the outcome of the formal investigation. During the hearing, petitioner did not present any evidence and instead moved that the secretary inhibit himself, which motion was denied. Later, the secretary rendered a decision finding petition guilty as charged and ordering his removal from office. The vice-governor, Melvin Vargas, was installed as governor. In this appeal, the power of the secretary to suspend officials was repealed by the 1987 Constitution, and that the act of disloyalty committed by petitioner was not proven beyond reasonable doubt. While the case was pending before the SC, petitioner filed his certificate of candidacy for the position of governor of Cagayan. 3 petitions for disqualification were filed against him on the ground that he had been removed from office. The Cumlic granted the petition. Later, this was reversed on the ground that the decision of the secretary has not yet attained finality and is still pending review with the court. As petitioner won by a landslide margin in the elections, the resolution paved the way for his eventual proclamation as governor of Cagayan. Issue 1. The Secretary has the power to suspend or remove local government officials as alter ego of the President. Held, yes ratio. Petitioner's re-election to the position of Governor of Cagayan has rendered the administrative case pending before us moot and academic. It appears that after the canvassing of votes, petitioner garnered the most number of votes among the candidates for Governor of Cagayan Province, as held by this court in Aguinaldo v. Cumlic et.al. The re-election to office operates as a condonation of the officer's misconduct to the extent of cutting off the right to remove him. Therefore, the court should never remove a public officer for acts done prior to his present term of office. To do otherwise would be to deprive the people of their right to elect their officers. When the people have elected a man to office, it must be assumed that they did this with knowledge of his life and character, and that they disregarded or forgave his fault or misconduct, if he had been guilty of any. It is not for the court, by reason of such fault or misconduct, to practically overrule the will of the people. Clearly then, the rule is that a public official cannot be removed for administrative misconduct committed during a prior term. Since his re-election to office operates as a condonation of the officer's previous misconduct to the extent of cutting off the right to remove him, therefore, the foregoing rule, however, finds no application to criminal cases pending against petitioner for acts he may have committed during the failed coup. The power of respondent secretary to remove local government of officials is anchored on both the Constitution and a statutory grant from the legislative branch. The constitutional basis is provided by Articles 7 and X of the 1987 Constitution, which vest in the President the power of control over all executive departments, bureaus and offices, and the power of general supervision over local governments, and by the doctrine that the acts of the department head are presumptively the acts of the President unless expressly rejected by him. For the statutory grant found in BPBLG 337 itself has constitutional roots, having been enacted by the then Batasan Pambansa pursuant to Article 11 of the 1973 Constitution, Section 2. A similar provision is found in Section 3, Article X of the 1987 Constitution. Inasmuch as the power and authority of the legislature to enact a local government code, which provides for the manner of removal of local government officials, is found in the 1973 Constitution as well as Indiana the 1987 Constitution, then it cannot be said that BP 337 was repealed by the effectivity of the present Constitution. Moreover, in Bajabio et al. V. Davide, Jr. BP 337 remained in force despite the effectivity of the Constitution, until such time as the proposed Local Government Code of 1991 is approved. The power of the Secretary of the DILG to remove local elective government officials is found in SECS 60 and 61 of BP 337. As to petitioner's argument of the want of authority of the Secretary to appoint Melvin Vargas as governor, we need but point to Section 48 of BP BLG 337 to show the fallacy of the same. Equally without merit is petitioner's claim that before he could be suspended or removed from office, proof beyond reasonable doubt is required inasmuch as he is charged with a penal offense of disloyalty to the Republic, which is defined and penalized under Article 137 of the RPC. Petitioner is not being prosecuted criminally under the provisions of the RPC, but administratively with the end in view of removing petitioner as the duly elected governor of Cagayan province for acts of disloyalty to the Republic where the quantum of proof required is only substantial evidence. Reyes v. Cumlick. Facts, GR number 120905. Renato Reyes was the incumbent mayor of the municipality of Bongabong, Oriental Mindoro. An administrative complaint was filed against him with the Sangguniang Panlalawigan by Dr. Ernesto Manalo. It was alleged that petitioner exacted and collected P50,000,00 from each market stallholder in the Bongabong public market. Also, that certain checks issued to him by the National Reconciliation and Development Program of the DILG were never received by the municipal treasurer nor reflected in the books of accounts of the same officer, and that he took 27 heads of cattle from beneficiaries of a cattle dispersal program after the latter had reared and fattened the cattle for 7 months. The Sangguniang Panlalawigan found petitioner guilty of the charges and ordered his removal from office. Petitioner filed a petition for certiorari, prohibition, and injunction with the RDC of Oriental Mindoro. Later, the presiding officer of the Sangguniang Panlalawigan, Vice Governor Pedrito Reyes, issued an order for petitioner to vacate the position of mayor and peacefully turn over the office to the incumbent vice mayor. But service of the order upon petitioner was also refused. Meanwhile, petitioner filed a certificate of candidacy with the Cumlic. Rogelio de Castro sought the disqualification of petitioner as candidate for mayor, citing the LGC. The Cumlic cancelled petitioner's certificate of candidacy. However, the Municipal Board of Canvassers of Bongabong, apparently unaware of the disqualification of Reyes by the Cumlic, proclaimed him the duly elected mayor. The Cumlic and Bank affirmed. Invoking the ruling in the case of Aguinaldo v. Santos, petitioner argues that his election on May 8, 1995 is a bar to his disqualification. GR number 120940. Julius Garcia, who obtained the highest number of votes next to Reyes, intervened, contending that because Reyes was disqualified, he was entitled to be proclaimed mayor of Bongabong, Oriental Mindoro. The Cumlic and Bank denied Garcia's prayer since a candidate who obtains the second highest number of votes in an election cannot be declared winner. Issue 1. The decision of the Sangguniang Panlalawigan is not yet final because he has not been served a copy thereof. Held no ratio. The failure of the Sangguniang Panlalawigan to deliver a copy of its decision was due to the refusal of petitioner and his counsel to receive the decision. As the secretary to the Sangguniang Panlalawigan, Mario Manzo, stated in his certification, repeated attempts had been made to serve the decision on Reyes personally and by registered mail, but Reyes refused to receive the decision. If a judgment or decision is not delivered to a party for reasons attributable to him, service is deemed completed and the judgment or decision will be considered validly served as long as it can be shown that the attempt to deliver it to him would be valid were it not for his or his counsel's refusal to receive it. Indeed, that petitioner's counsel knew that a decision in the administrative case had been rendered is evident in his effort to bargain with the counsel for the Sangguniang Panlalawigan not to have the decision served upon him and his client while their petition for certiorari in the RDC was pending. His refusal to receive the decision may, therefore, be construed as a waiver on his part to have a copy of the decision. The purpose of the rules on service is to make sure that the party being served with the pleading, order, or judgment is duly informed of the same so that he can take steps to protect his interests. Enable a party to file an appeal or apply for other appropriate reliefs before the decision becomes final. Petitioner was given sufficient notice of the decision. Prudence required that, rather than resist the service, he should have received the decision and taken an appeal to the office of the President in accordance with RA number 7160. 67. But petitioner did not do so. Accordingly, the decision became final on April 2, 1995, 30 days after the first service upon petitioner. The net result is that when the elections were held on May 8, 1995, the decision of the Sangguniang Panlalawigan had already become final and executory. The filing of a petition for certiorari with the regional trial court did not prevent the administrative decision from attaining finality. An original action of certiorari is an independent action and does not interrupt the course of the principal action nor the running of the reglementary period involved in the proceeding. Consequently, to arrest the course of the principal action during the pendency of the certiorari proceedings, there must be a restraining order or a writ of preliminary injunction from the appellate court directed to the lower court. In the case at bar, although a temporary restraining order was issued by the regional trial court, no preliminary injunction was subsequently issued. The temporary restraining order issued expired after 20 days. From that moment on, there was no more legal barrier to the service of the decision upon petitioner. Issue 1. Petitioner's re-election rendered the administrative charges against him moot and academic. Held no ratio, the case at bar is the very opposite of Aguinaldo vs. Cumlick. Here, although Reyes brought an action to question the decision in the administrative case, the TRO issued in the action he brought lapsed. With the result that the decision was served on petitioner and it thereafter became final on April 3, 1995, because petitioner failed to appeal to the office of the President. He was thus validly removed from office and, pursuant to 40 of the LGC, he was disqualified from running for re-election. It is noteworthy that at the time the Aguinaldo cases were decided there was no provision similar to 40 which disqualifies any person from running for any elective position on the ground that he has been removed as a result of an administrative case. RA number 7160 could not be given retroactive effect. Furthermore, the decision has not yet attained finality. As indicated earlier, the decision of the then Secretary of Local Government was questioned by the petitioner in this court and that to date, the petition remains unresolved. All in all, herein Mayor Reyes was given by this Sangguniang a period of 61 days to file his verified answer. However, he resorted to dilatory motions which in the end proved fatal to his cause. Veritably, he neither filed nor furnished the complainant a copy of his answer. Failure of the respondent to file his verified answer within 15 days from receipt of the complaint shall be considered a waiver of his rights to present evidence in his behalf. Art. 126 of Rules and Regulations implementing the Local Government Code of 1991. All persons shall have the right to a speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. Indeed, it appears that petitioner was given sufficient opportunity to file his answer. He failed to do so. Nonetheless, he was told that the complainant would be presenting his evidence and that he would then have the opportunity to cross-examine the witnesses. But on the date set, he failed to appear. He would say later that this was because he had filed a motion for postponement and was awaiting a ruling thereon. This only betrays the pattern of delay he employed to render the case against him moot by his election. Issue 1. Julius Garcia should be declared mayor in view of the disqualification of Renato Reyes. Held no ratio, that the candidate who obtains the second highest number of votes may not be proclaimed winner in case the winning candidate is disqualified is now settled. To simplistically assume that the second placer would have received the other votes would be to substitute our judgment for the mind of the voter. The second placer is just that, a second placer. He lost the elections. He was repudiated by either a majority or plurality of voters. He could not be considered the first among qualified candidates because in a field which excludes the disqualified candidate, the conditions would have substantially changed. We are not prepared to extrapolate the results under the circumstances. Garcia's plea that the votes cast for Reyes be invalidated is without merit. The votes cast for Reyes are presumed to have been cast in the belief that Reyes was qualified and for that reason cannot be treated as stray, void, or meaningless. The subsequent finding that he is disqualified cannot retroact to the date of the elections so as to invalidate the votes cast for him. As for Garcia's contention that the Cumlic committed a grave abuse of discretion in not deciding the case before the date of the election, suffice it to say that under RA No. 6646, 6, the Cumlic can continue proceedings for disqualification against a candidate even after the election and order the suspension of his proclamation whenever the evidence of his guilt is strong. For the same reason, we find no merit in the argument that the Cumlic should have seen right away that Reyes had not exhausted administrative remedies by appealing the decision of the Sangguniang Panlalawigan and, therefore, should have disqualified him before the elections.